obviously with the second assignment, there, because you are doing oral submissions and we're building a different skill set. And by the way, I've put up some rather helpful extra materials. Thanks, Gail Griffiths, for asking the question about extra resources to support you on your merry way as you confront the whole issue of doing moots. There's a good PDF by a University of Tasmania lecturer up there that I've put in the two-party discussion forum under the Assessment 2 tab. Quite a nice little, reasonably concise document that should help you get your head around, you know, the practicalities of the exercise. But more importantly, I think everyone should be looking at those exemplar videos that I've posted up online. They should assist you to some degree. There's no real hard and fast rules in terms of the way that you argue and the structure that you use. But obviously, you know, if you can craft a nice logically flowing argument, to that extent, it's not really that much different from the application section in your IRAC, is it? So this is where you kind of get to cut yourself free from the IRAC format a bit and go for gold with your argument building technique. I did post, I know that some people felt that the first assignment, like, wow, thank goodness that's over. And we had some discussion in the chat box just before about, oh, thank goodness that's over. Yes, and to some extent, I did want to address that this evening because, you know, with law school, as you forge ahead, you need to kind of buckle up, peeps, because, you know, it's the whole of law school will be a challenge, but no more so than the first year, and no more so probably than the second half of the first year, and that's exactly where Contract B falls, because the first year is all about learning so many new and different skills, amongst them, rightfully so, right? Yeah. You're building a whole lot of different skills, and particularly you're learning the most core, most essential skills that you will be honing basically for the rest of your degree and the rest of your career. So there's a lot of new stuff going on. There's not just learning how to construct a really good, legally compelling argument, but there is also how to do legal research, how to wrap your mind around using case-based, using Westlaw, reading, you know, the mountain of stuff that you have to read as a lawyer, learning how to read efficiently. And we have covered in some of our Zooms, you know, how I go about trying to read efficiently. Now we'll be confronting, you know, learning how to do a moot. This may be the first moot for some of you. So you need to be bedding down those skills, early skills of presenting. In your case, it'll be presenting to the video camera. But I want you to try and imagine as much as you can that the camera is in fact a live judge. And I have been considering whether or not, you know, we can introduce some live mooting, because there's nothing quite like the experience of actually doing a live moot to help you appreciate the value of thinking on your feet. There's one thing to script up something and to perform it in front of your video at home. But it's another thing really to have somebody else kind of eyeballing you and listening intently to every word you say and interjecting on occasion and asking you for further or more detail on a certain point. Now watch this space, I might be able to do that, I might not. But to that end, what just picking up on what I just said, I really want to make sure that I impress upon you for this second assignment, try and I'm fine for you to have a script up if you feel that you need to do so. And having it on your computer screen is often best, so that if you do need to refer to a point, you're just doing these ones, rather than if you've got it on a desk or propped up in front of you. It's a bit more difficult to keep eye contact. But as much as you can, think of yourself as having a conversation with me, because that's how I'm going to be viewing your video, isn't it? I'm going to be sitting in my little study here with my parents, and I'm going to be watching you as though we're having a conversation. And the more you can make your oral submissions like a conversation, like a chat with a judge, the better off you will be, the more effective your legal argument will be, funnily enough. Judges are actually people, and they actually like to be talked to. They will talk at you if they feel the need arises, but they very much appreciate the niceties of just speaking at a normal, natural pace, emphasizing words where you need to emphasize, getting emotive if you need to get emotive in a restrained and barrister-like fashion. I think Marcus does a reasonable job of that. I think I posted one of Marcus's one of his media releases up online when one of the past cohorts were mucking around. If you do want to have a practice with your videos, I would strongly recommend you having a muck around and posting something up. You can post up whatever you do to YouTube and send me the link, and then I can embed it up on the forum for you, the dual party forum, so both plaintiff and defendant forum, just so that if you want to get a bit of early feedback on your presentation style, or even if you just want to sledge the other team. And that's kind of what it got down to last time. I'm more than happy for you guys to do that. It is worth it, and some of the constructive feedback that came out of last one was quite good. People really did, I found, improve as they went along. Some people got kind of addicted and did a number of news bites, media releases, and we had a whole sledging thing going on. It was quite fun. So if you do want to muck around and practice your stuff, please feel free to do so. Just send me the link, as I said, and I can embed it in Moodle for you. Otherwise, you can just post it up in a forum, in that dual party forum, I think, because then you've got your widest audience and most opportunity for feedback. If there are any other queries that crop up in relation to the exercise, then just shoot me an email or send me a note on the forums, and I'll certainly respond to that. I don't know if many of you guys got my my rather long-winded post today that I put up on Moodle, just to give you a bit of inspiration for the back half of the course. If you haven't had a look at that, then I would recommend you do so. I know that there are quite a few people that are doing it tough just with life circumstances at the moment in our cohort, and I just wanted to give you a bit of a pep talk, put some wind back in your sails. So watch out for that. Go and have a look for that. It's already up on Facebook. So the only other thing I had to mention of an administrative nature was the necessity for everyone to nominate themselves as counsel for either plaintiff or defendant in the upcoming assignment. Once you do that, you will be automatically populated into the defendant's or the plaintiff's discussion forum, and I've arranged it so that the defendant counsel cannot see the plaintiff one and the plaintiff counsel cannot see the defendant one, so that we can have a full and free discussion in those discussion fora. So, message each other to your heart's content. Oh, that's the other thing. The nomination of acting as counsel for either plaintiff or defendant will also populate you into a message group. So you can actually, oh good, I'm glad you're cool with the feedback. So you can actually message each other on Moodle. Did you even know this? How many people knew that you can message each other in Moodle? Can I have a Y or an N in the chat box? Were all you people just hiding this functionality from me? Oh, I have a whole lot of people saying no. Since when? Yeah, you can. And so the way I've set it up, once you've populated yourself into plaintiff or defendant camp, I will share my message screen and I will show you how to do it. Okay. So here we are at our homepage. And you just, here, there's your profile. You click on that. Ha! Look at that! Messages. Wow, never knew that was hiding there, hey? So if you click on that, ta-da! Awesome. So there is your message function. And message each other to your heart's content, as I said. The more that you chat with this assignment, I find, the better off you do. So get chatting. The plaintiff discussion forum is actually it's going off at a cracking pace. Thanks, Gail. And yeah, any questions? Just shoot them through to me. Other than that, are there any preliminary questions? Oh, the other thing was for anybody that wants to do a Zoom from their first assignment work, I am more than happy to sit down and chat with you so that you feel supported and so that we can step you through everything if you wish to do so. So again, just set up time with me and or even if you just want to set up a Zoom for a chat at this point in time, it's kind of halfway, please feel free to set up a Zoom with me. I would be only too pleased to make time to sit down and chat with you. Any queries on any of that? Jay said, do you, if I recall your question correctly, you said, do you apply Queensland legislation by default, given that the jurisdiction is New South Wales? Is that what you said, Jay?
Sorry, I think it was something to do with do I start with Queensland jurisdiction, any type of case or legislation, just because I'm in like New South Wales, so I kind of am a little bit confused. Do I start with any cases in Queensland or that have been heard in Queensland and then move my way up, or how does it work?
Excellent question. Okay, so that tells me that we need to refresh our memory about the legislation, the Australian Consumer Law. What kind of legislation is that legislation? Well, first, let me ask you, what is the actual piece of legislation that the Australian Consumer Law lives in? What is that piece of legislation called, and what jurisdiction is that in?
Federal Competition and Consumer Act.
Competition and Consumer Act, and it is a Commonwealth Act. So wherever you have, okay, let's go back to a little bit of what I'm hoping that you might have looked at in week 2, together with a little bit of what you should have touched on, I'm hoping, in contract A when you were talking about consumer guarantees. The Competition and Consumer Act is a federal piece of legislation, as you say, However, there was a specific reason why the ACL was included as a schedule. Does anybody know? 10 gold stars and a brownie point. To anyone who knows? Nope. Okay. So there was a very, very long and turgid history of consumer protection legislation going back through the 1950s onwards. And it was just a dog's breakfast of a mess. And each state had its own little regime. No one really wanted to give up their little patch of territory. But it was a real pain because where you had interstate trade like we have in our problem scenario, it was a thicket of legislation because you had Queensland legislation, you'd have every state and territory legislation. If you were trading everywhere in every state and you were trading in an interstate fashion, you'd have to deal with multiple pieces of legislation, and it was a pain in the butt. So ultimately what happened was we got the Trade Practices Act on board. And my word, that was a real achievement. There were so many different state agreements and handshake deals that had to go on to get that legislation on board. Now, in terms of the way that the ACL is structured now, it's in a schedule so that each state and territory, so you've got the federal legislation that operates federally, and you have the ACL being contained in a nice little schedule so that each state and territory could enact that schedule as home legislation, as state-based legislation. So you have a Granddaddy Act over the top, and you have state legislation that mirrors the federal legislation. That's convenient because if you're doing constitutional law, you will know that the Commonwealth only has powers to legislate in narrow areas, and they are set out in Section 51 of the Constitution. One of those powers is to legislate in terms of companies, corporations, okay? One of those powers is postal, telegraph, telephone. One of those powers is patents, obviously. That's my area of expertise. One of those areas is interstate trade. And so therefore, the Commonwealth legislation applies to any of the conduct that can be caught by a Commonwealth Act. And that's why the Competition and Consumer Act is principally drafted every, well, let's just, here, I'll start sharing again. Okay, let's share. Okay, so I've gone straight to the actual, all right, we'll go here, section 18. Oh, let's go down section 18. Oh, hope you're not getting dizzy. Here. What does it say? A person must not in trade or commerce. Person. So let's go. Person includes a partnership. But the only person, the reason why it's drafted as person, because it's in the schedule and states have the legislative power to legislate over persons. But the Commonwealth does not. So for the Commonwealth, person will principally be a company because they have power to catch naughty companies under Section 51 of the Constitution. A person may also be a person if they are using one of the other constitutional powers that will allow the Commonwealth to catch them, like using the phone, post, telegraph, as it says. Telecommunications, Commonwealth can catch them, okay? So the Commonwealth Act will deal with interstate trade. Okay, does that make sense, Jay? So for where you are looking at, and because all of the pieces of legislation are the same, and because this legislation here, this Section 18, is the same as Section 52 of the Old Trade Practices Act, then any case that deals with the old Section 52 or any case that deals with Section 18 of the ACL will be persuasive for the purposes of this piece of legislation. Okay.
What about fair trading? Sorry.
I was going to say, obviously, if you are instituting your proceedings in the federal court, then you've got your whole system of binding precedent. But I guess what I'm saying is that you'll find pretty much any case on the old Section 52 will be authority for the new Section 18. That was a piece of Commonwealth legislation as well. But if you're talking about a case that was decided under the equivalent of Section 18 in a jurisdiction, you can still quite happily cite that in front of the federal court. Okay? You still have the system of precedent that is binding on the federal court, but I'm not terribly worried about. There are most of the authorities that we cite for misleading or deceptive conduct tend to be high court cases, because this has been a super duper litigated piece of legislation. But anything from the old Section 52 will be good case law so far as Section 18 is concerned. Does that?
Yeah, I think that answers the majority of it, because it was also to do with Fair Trading Act and the Sale of Good Act, because each state has a different act and different provisions, especially when it comes to how the Fair Trading Act then also applies, I guess, each interpretation, and then how it also applies to the ACL as well, if you get where I'm coming from.
Yes, just because we got this nice federal legislation didn't tidy up the whole area. And as I said, there were so many deals and political meetings and handshakes that had to happen to get this stuff on board. The states didn't want to cede their legislative power to Commonwealth at all. And so their fair trading legislation, a lot of them have just maintained it. So
is it still good law? Like you can still apply the Fair Trading Act, and it will still, like, it obviously won't be the same or have the same effect as the ACL, but it will still have a similar effect to a certain degree.
Well, unless it's been repealed. I mean, a lot of the states got rid of, some of their legislation when this stuff came on board. I mean, everybody held hands and said, okay, this is the date that it's all coming on board. And, everyone's enacted mirroring legislation. It all had to be done in 2010 by a certain time, and there were sunset provisions and whatnot. So at least there is that amount of consistency that is, that is apparent and available to litigants now. I can't tell you about the New South Wales Fair Trading Acts because I'm a Queensland girl, and so my home legislation is Queensland. But all you'd have to do is just look it up on the New South Wales legislation website and see whether it's still in force. If so, it'll have to have in there, I would imagine, sometimes some states hide the ACL in their fair trading acts. Some have gotten rid of their fair trading equivalent legislation. Some have, it is a bit of a mess, but I can't specifically advise on New South Wales, but I hope you're not wandering into that for the purposes of the assignment. Please do.
Okay, so I don't have to worry about that. Okay, fine. That makes sense.
Please do not. And that is the whole reason why I stated the question as misleading or deceptive conduct, because it's the statutory phrase. Here's a good tip for you. Normally with assignments, well, this is me anyway, I don't do assignments by ambush. That is, I don't tend to set assignments that make you examine legislation and concepts like, you know, the home state-based legislation that are not specifically discussed in Wilmot or specifically advised by me on an instructions sheet. Okay, so I don't expect you to look at other pieces of legislation here. For the purposes of our course, we had week 2 that dealt with the Australian Consumer Law and Section 18 specifically as the statutory version of the common law of misrepresentation. And that's what we can confine ourselves to happily for the purposes of this assignment. And now I think we've probably got to the point where I could have, if your question was, do we have to worry about state legislation? I could have probably answered that question in about 30 seconds. Sorry, it's taken us a bit of a merry dance to get to the end of that one.
Thank you. Thanks.
It's okay. And for anyone else watching, please do not, please do not look at any other legislation except for the Australian Consumer Law and the Competition and Consumer Act. So far as our particular problem goes and the misleading or deceptive component. Any other queries? Any other queries? Nope. I will stop sharing. Alrighty, well, thank you, folks. Have a pleasant evening, and I will catch up with you next week. Hope to chat with you in the Plaintiff or Defendant forums, or any of the other forums, or on Facebook. Bye, guys. Thanks, Michelle.